Section 3, Opening a Real Estate Office. Brokerage business entities. Types of business entities that may register as a brokerage entity include the following: sole proprietorship, general partnership, limited partnership, limited liability partnership, corporation, and limited liability company. A sole proprietorship is a business owned by one person. A real estate brokerage sole proprietorship exists when the broker is the only owner. Sole proprietors are personally liable for the business losses as well as the debts and torts of the sales associates and others working for the broker when acting within the scope of their duties. A general partnership is an association of two or more persons for the purpose of jointly conducting business. General partners are agents for each other. One partner entering into an agreement binds the other partners to the agreement. Florida general partnerships are not subject to direct taxation. General partnerships feature pass-through treatment for federal income tax purposes. At least one partner must be an active real estate broker in a general partnership real estate brokerage. Partners who deal with the public and perform services of real estate must also be active brokers. A limited partnership is composed of both general partners and limited partners. Limited partners invest cash and may not participate in management. Limited partners have limited liability. All general partners who expect to perform real estate brokerage services on behalf of the limited partnership must be licensed as active brokers. Sales associate and broker associates may not be general partners in the real estate brokerage limited partnership. However, they may be limited partners. A corporation is an artificial person or legal entity created by law, consisting of one or more individuals. At least one of the corporation's officers or directors must be licensed as an active broker. Active Florida brokers, inactive Florida brokers, and unlicensed people may serve as officers and directors of a real estate brokerage. However, officers and directors who deal with the public and perform services of real estate must be licensed as active brokers. Sales associate and broker associates may not be officers or directors in a real estate brokerage corporation. Sales associate and broker associates may be shareholders of a real estate brokerage corporation. An ostensible partnership or quasi-partnership exists where there is no real partnership, but the parties act or do business in such a manner that the public assumes that there's a partnership. Ostensible partnerships are considered fraudulent and deceitful, and any licensees who operate as ostensible partners are subject to discipline. A trade name is a business name other than the legal name of the person doing business. A broker or brokerage entity may use a trade name after the name is registered with the DBPR. Fictitious name refers to the name registered with the Department of State. To have an active status, a real estate broker is required to open an office and register it with the DBPR. If a broker desires to conduct business from additional locations, the broker must register each additional location as a branch office and pay the appropriate registration fees. Registrations issued to branch office are not transferable to another location. If a broker desires to conduct business from additional locations, the broker must register each additional location as a branch office and pay the appropriate registration fees. Registrations issued to branch office are not transferable to another location. In regards to office signs, the brokerage office sign must contain the trade name if applicable, the broker's name, and the words licensed real estate broker, or you can abbreviate it as is. If desired, the names of the sales associates and broker associates may be added below the broker's name. provided the appropriate titles, such as sales associate or broker associate, appears after their name. A line or space must separate the broker's names from the associates' names. The American with Disabilities Act prohibits discrimination in places of public accommodation and commercial facilities such as hotels and real estate offices. All advertising must be in the name of the brokerage and under the supervision of the broker. Licensees who include their personal name in advertisements must use their last name as registered with the DBPR. Blind advertising fails to disclose the licensee name of the brokerage firm and provides only a post office box number, telephone number, and/or street address. The point of contact information refers to the information provided on the internet for contacting a brokerage firm or individual licensee, including mailing addresses, physical street addresses, email addresses, telephone numbers, and fax telephone numbers. The brokerage firm must be above, below, or adjacent to the point of contact information. Failing to provide accurate and current rental information for a fee is a first-degree misdemeanor. The penalty for a first-degree misdemeanor is a fine of not more than $1,000 and/or up to 1 year in jail. A telephone solicitation is a telephone call placed for the purpose of encouraging the purchase of, investment in, property, goods, or services. Telemarketers, including real estate licensees, must search the National Do Not Call Registry before making telemarketing calls. Violators of the Federal Telephone Consumer Protection Act may be fined up to $43,792 per call. The penalty for violating Florida's Telemarketing Act is $10,000 per call.